Welcome to The Deep Dive. We're here to unpack significant legal cases, and today we're looking at a key Supreme Court environmental law decision, Wirehouser Company versus the United States Fish and Wildlife Service.
That's right. And the central issue was pretty fascinating. Could the Fish and Wildlife Service, the FWS, designate private land as critical habitat for the endangered Dusky gopher frog?
Right, even though the frog wasn't living there, and the land, well, it didn't really have the right features for it at that moment.
Exactly. The government argued it could be restored with, quote, reasonable efforts. That phrase became really important.
So what was the final word from the court?
Ultimately, the Supreme Court sided with Wirehouser. They found the FWS designation wasn't proper because the land as it stood wasn't technically habitat for the frog under the Endangered Species Act, the ESA.
Okay, but it wasn't a complete win just on that point, right? Didn't they send part of it back?
They did. The case was sent back, remanded, for the lower courts to properly consider the economic impact analysis specifically, whether the service adequately weighed the costs of designation against the benefits when deciding not to exclude the land. So, two main takeaways from the court.
Got it. So let's dive into those arguments. Wirehouser first. What was their main line of reasoning?
Their core argument was that Congress actually narrowed the definition of critical habitat back in 1978 when they amended the ESA.
How so? Which parts of the act were they pointing to?
They focused on Section 4, which talks about designating any habitat, which is then considered to be critical, and crucially Section 3, subsection 5C. That part says critical habitat cannot include the entire area which can be occupied by a species.
Okay, so putting those together, what was the implication for Wirehouser?
They argued these sections set an outer limit. So land to be designated, especially unoccupied land, it first had to be habitat. It had to be land the species could, currently occupy or use.
Which raises that big question. Is the ESA about what the land is now or what it could become?
Precisely. And that came up directly in the oral arguments.
Oh, yeah, I remember Justice Kagan posed a hypothetical, didn't she? Something about a species losing its only home.
She did. She asked, what if the only place a species lives becomes unlivable? Could you designate another area, one that just needs some reasonable efforts to make it suitable, as unoccupied critical habitat?
And Wirehouser's lawyer, Mr. Bishop, what did he say?
He stuck to their guns. He said no, essentially. The area must first qualify as habitat. He did concede that maybe, tiny changes, de minimis changes, might be okay.
But the changes needed for the frogland were much bigger than that.
That was his point. He argued the scale of restoration needed on Wirehouser's property went way beyond de minimis. It really crystallized their whole argument about the meaning of habitat.
So they pushed back hard on the government's broader view of habitat.
Absolutely. They challenged the idea that habitat could mean places the species doesn't currently live, but could potentially live after restoration. They brought up dictionary definitions, international agreements, like the Convention on Migratory Species from '79.
What did those say?
Things like habitat being an area with suitable living conditions, or the Forest Service definition talking about the environment having all the essentials for survival. For the Dusky gopher frog, Wirehouser said these temporary ponds, used just for breeding,
weren't enough to count as full habitat.
Right. Because habitat, they argued, has to be land that can be occupied, meaning the frog could actually live its life cycle there, not just visit for a short time. The uplands were missing.
But didn't the government, or maybe one of the justices, bring up migratory species, like birds that are only somewhere temporarily?
Yes. I think Justice Ginsburg raised that. Mr. Bishop tried to distinguish that. He said for a migratory bird, its habitat is the whole range, summering areas, wintering areas, places they stop over. It's all connected, necessary habitat.
Unlike the ponds alone for the frog.
Exactly. He argued the ponds, without the surrounding suitable upland forest, just didn't meet the definition. Then Justice Kagan pushed back again.
What was her point?
She asked, well, if an area could be made suitable with reasonable improvements, wouldn't the law prefer designation over letting the species go extinct if its current home fails? It's a powerful question about the purpose of the act.
So Wirehouser's position really boiled down to there's a difference between unoccupied land that is habitat and land that is not habitat but maybe could be someday.
That's the core distinction they were making. And Justice Alito picked up on that, asking if the choice was really just designation or extinction. Is there nothing in between?
And Bishop's response?
He said, no, it's not that stark. He pointed to Section 5 of the ESA, which the court discussed in the Sweet Home case. It gives the government authority to actually buy land that could become habitat in the future.
So other tools exist besides designation.
Right. He also mentioned the definition of conservation in the Act itself. It includes things like maintaining existing habitat, even translocating species. But crucially, he argued, it doesn't mention creating brand new habitat or restoring land back to some pre-human state.
So maintain what you have, move species if needed, but don't force landowners to completely remake their land into something it isn't.
That was the gist of their interpretation.
Yeah.
Justice Kagan, though, seemed skeptical. She suggested the Act itself frequently talks about habitat needing improvement or management.
Implying it's not always about pristine, untouched areas.
Exactly. But Bishop countered that those references are about maintaining or improving existing habitat, not creating it from scratch on land that doesn't currently qualify.
Then the conversation shifted a bit, didn't it, to whether the case was even ready for court. Ripeness.
Yes, Justice Ginsburg raised that. She asked, since Wirehouser wasn't actually being stopped from logging or forced to do anything yet, was their injury real enough for the court to step in?
That's a classic procedural hurdle. How did Wirehouser overcome that?
They argued the designation itself caused immediate harm, a big hit to their property value.
How much?
They cited the FWS's own economic analysis, which apparently estimated the loss in the tens of millions of dollars. Plus, they'd spent money on trying to rezone the land for development, which was now wasted effort because of the designation.
Justice Sotomayor questioned who actually suffered that loss, right? Since Wirehouser mostly leased the land.
She did. But Bishop clarified that Wirehouser did own a portion, about 150 acres, and as the lessee and owner, they incurred those financial hits and wasted expenses directly.
Sotomayor also seemed to probe whether the land was really uninhabitable for the frog. Didn't she mention stumps?
Yeah, she noted there might have been some potential shelter, maybe frogs survived there during logging. It questioned the lower court's finding that it was definitely uninhabitable. It gets back to that definition of habitat.
What definition did Wirehouser offer?
They went with a sort of dictionary definition: physical features naturally or normally preferred by the species, and land which contains suitable living conditions. And they argued the record showed their land needed a total overhaul to become the kind of open upland savanna the frog needs.
Okay, let's flip to the government side, the Fish and Wildlife Service. What was their counter-argument?
Their main thrust was simple. The Dusky gopher frog is critically endangered, basically on the brink. And they argued this specific area, Unit 1, was essential for the species conservation, to reduce the very real risk of extinction.
So designation was necessary, even if the habitat wasn't perfect right now.
Yes, they argued that critical habitat doesn't need all the elements immediately, as long as reasonable restoration could provide the missing pieces.
Which brings us back to reasonable restoration. Chief Justice Roberts jumped on that, didn't he? With that Alaska hypothetical.
He did. The famous greenhouse in Alaska example. How far does reasonable stretch? Could you designate Alaska tundra if you could theoretically build a greenhouse?
A vivid way to ask about limits. How did the government lawyer, Mr. Needler, respond?
Needler argued the service had found that restoring the upland forest on Wirehouser's land could be done with reasonable effort. And importantly, he said it doesn't matter what the current landowner wants to do. The Act looks at the land's potential, its status, not the owner's intent.
But Justice Alito pressed further on reasonable. What does it mean? And who pays? Especially if it's, say, a small family farm, not a large company.
Needler didn't really offer a hard and fast rule. He suggested looking at whether the restoration could align with the existing land use. Like for timber farming, maybe thinning trees is reasonable because it fits within forestry practices.
Justice Breyer then chimed in about the Secretary of the Interior's discretion, right?
Yeah. He basically asked, what evidence shows this specific designation is a reasonable exercise of discretion and not way out there like the Alaska greenhouse?
What evidence did Needler point to?
He mentioned photos in the record showing trees already on the property. He suggested thinning them would be compatible with the ongoing timber use. He also tried to downplay the immediate impact, saying routine logging hadn't required federal permits, only a major change like development would trigger that kind of review under Section 7.
Justice Sotomayor came back to the definition of habitat, though.
She did, noting the dictionary definition seemed narrower than the service's view. Needler's response was that the relevant definition here is the kind of site the species needs to thrive these very rare ephemeral ponds surrounded by the right kind of upland forest.
And he emphasized the ponds themselves.
Absolutely. He stressed how crucial they are. While adult frogs only use them briefly for breeding, the larvae, the tadpoles, need that specific kind of fish-free water for a long time, like 195 days.
Did he concede the uplands needed work?
He acknowledged that long-term survival would require changes to the tree cover and the ground cover. He mentioned some evidence of stumps frogs might use, but said the exact level of current habitability wasn't the main fight during the agency process. The focus was the potential and the necessity of the site.
Did the government talk about alternatives like buying the land?
They mentioned things like grant programs to states under Section 6, and yes, the possibility of purchase, though they noted eminent domain is rarely used for this. But their point was, these other tools don't negate the mandatory duty under the Act to designate critical habitat when it's warranted.
They argued designation on private land is expected under the Act.
Pretty much. And that the limits Wirehouser wanted would hamstring conservation on federal lands too, by restricting the Section 7 consultation process where agencies check if their actions harm species or critical habitat.
What's the benefit of designation on federal land then?
Needler argued it brings the Fish and Wildlife Service's expertise into the consultation process. He also pushed back against Wirehouser's idea that habitat has to be usable immediately, arguing conservation is inherently a long-term game.
And he kept distinguishing this case from the Alaska greenhouse.
Yes, saying the restoration here, thinning existing pines, maybe planting native longleaf pines, aligns with the land's timber use, unlike building a structure in a totally different climate. He suggested it could be gradual, citing restoration efforts at another site, Glen Pond in Mississippi.
So the government's bottom line was, the ponds make it essential, restoration is reasonable, and the land's potential matters most.
That's a good summary. He reiterated that the nature of the land, those rare ponds, makes it critical for the frog's survival, even if the current owner won't do the restoration. He even suggested that under a proposed future regulation, this area would likely still qualify because the ponds are so vital, with maybe less weight given to landowner intent for the surrounding area.
Justice Gorsuch asked about the Secretary's general duty versus this specific designation, right?
He did. Needler responded that while the Secretary has a broad duty to protect species, designating critical habitat is a specific legally mandated process. It involves rulemaking, public input, science, cost considerations. It's the main tool the Secretary have to directly influence conservation on private land independently.
Okay, that covers the government. What about Wirehouser's rebuttal, their final chance to respond?
They came back swinging on a few key points. First, they clarified that all federal agencies have a general duty to conserve species under Section 7A1, not just when critical habitat is designated. Think Clean Water Act permits species protection happens there too.
So designation isn't the only way to protect the frog.
That was their point.
Yeah.
They also noted that the restoration in Mississippi Needler mentioned. That happened before the land there was designated critical habitat.
Undercutting the idea that designation is required for restoration.
Perhaps. They also strongly disputed the idea that the needed changes were in sync with current use. Creating an open savanna, they said, is the opposite of running an intensive tree farm. The dense trees block sunlight needed for the ground cover the frog needs.
And they brought up the scientists again?
Yes. They asserted that frog experts cited in the record, Lanoux, Pechman, Revolved, didn't say the land is habitat now. They said it could be restored with significant effort, like prescribed burning. None called it suitable currently.
Hammering home that distinction again.
Exactly.
Good.
They circled back to the word habitat in Section 4 and the can be occupied limit in Section 3, arguing these imply immediacy. They also pointed to the word maintenance in the definition of conservation, suggesting it means keeping what exists, not total transformation.
And they mentioned the other options again. Buying the land, state action.
Yes, reminding the court other powers exist beyond critical habitat designation. They suggested the frog survival didn't hinge solely on this designation on this land, and noted the government hadn't even approached landowners about conservation easements.
What about Justice Sotomayor's point about the lack of other suitable ponds?
They acknowledged the rarity, but argued other acquisition methods exist. And they criticized the likely outcome if permits were sought. The government might demand 60% of the land be set aside for the frog, which Wirehouser felt was totally inappropriate for land that isn't currently habitat.
Okay, that lays out the arguments really clearly. Now let's move to our 10th chair perspective. If you were sitting as that hypothetical 10th justice hearing these arguments, what's your take? Expert speaker, 10th chair perspective. All right, stepping into that 10th chair role, this case really hits that classic friction point between endangered species protection, which is obviously critical, and private property rights. The ESA is a powerful law, maybe one of the most powerful environmental laws we have, but applying it to private land always requires careful thought, especially with unoccupied habitat. Expert speaker, 10-chair perspective. Especially then. The absolute core here is, what does habitat mean in the context of the Act, particularly Section 4? And how far can the concept of reasonable effort for restoration stretch? The drive to prevent extinction is strong, and rightly so, but you have to look at the words Congress chose. And Wirehouser's argument was that those words point to current suitability. Expert speaker, 10th-chair perspective. That's how I read their argument, and it has some traction. Designating land that currently lacks essential features and needs pretty significant changes to get them, well, it pushes the boundaries of the agency's authority under the statute as written. That term, reasonable effort, is just inherently fuzzy, isn't it? Very subjective. Expert speaker, 10th-chair perspective. Exactly. It creates uncertainty for landowners. Now, those ephemeral ponds are clearly unique and important. No one disputes that. But the sheer scale of upland modification needed here makes me question if this land parcel, viewed as a whole, truly fits the bill of habitat right now under the Act. So what's the alternative? Just let the frog potentially lose that area. Expert speaker, 10th chair perspective. Not necessarily. The Act does provide other tools, as Wirehouser pointed out. Targeted land acquisition, buying the land, or conservation easements or cooperative agreements seem like potentially better fits for situations like this, maybe less confrontational, more tailored. And the economic side, the court sent back. Expert speaker, 10th chair perspective. That's crucial too. The court rightly emphasized that the service must properly weigh the economic impacts of designation when deciding whether to exclude an area. That balancing act is built into the statute. So my perspective leans towards the idea that the FWS might have overstepped slightly here by designating land that required such significant restoration to become functional habitat. A clearer definition or standard for habitat, especially unoccupied habitat, seems necessary to balance species protection with regulatory clarity and fairness to landowners. That really puts the dilemma into focus. So that wraps up our deep dive into the arguments in Wirehouser v. Fish and Wildlife Service.
We hope this breakdown gave you a good sense of the legal knots involved in the Endangered Species Act, and specifically this critical habitat designation process. Complex stuff.
Absolutely. What stood out most to you listening? Where do you think the balance lies between protecting species and respecting property rights? These are big questions with no easy answers. We definitely encourage you to keep thinking about them.
Thanks for joining us on the Deep Dive. We'll be back next time to unpack another fascinating topic.